last session. I'm just running out of time. I was very ambitious. I first identified 20 doctrines, then I cut it down to 10, then less than that. And now I think we'll end up probably doing 2 here and 2 earlier. So we'll do 4 doctrines, and I'll mention some of the other doctrines, but it's just to share a methodology with you. As Professor Danda very succinctly said, my whole attempt is to draw attention to the fact that there's such a thing called doctrine. And that doctrine drives actually the way we select precedents and case law and so on and so forth, because it's not as if, in my experience, anyone is being completely arbitrary. They have something in their head, and that's not purely social prejudice either. There is something between the law and the decision making, and that is, I believe, this area which are subtle ideas, things we believe are right, and which inform those particular areas. And those are the doctrines I identified yesterday, 2 doctrines, and today 4 doctrines. So we have actually 6 doctrines that we are dealing with. And these doctrines may come from obiter dicta. They may not be from ratio at all, but they're very powerful ideas, and I'll demonstrate that in terms of equality. From obiter dicta, and I have several obiter dicta, but because we have become so much in love with Chempakam Dorarajan, I will pick an obiter dicta from the Madras High Court judgment, actually, which I've used before. I know Justice Soundararajan was trying to reach a different result by looking at 46 and 15. But even he did not see 15 as able to assure equality. He had to reach out to 46. And then they brought in 29 and the chronology of 46 and 29 and so on. But his judgment, I very much, as Justice Butt correctly pointed out, is trying to go in a different direction. And he says, I have no choice. With hesitation, I agree with the Chief Justice. He actually writes in his judgment. It's like a quasi-dissent. He doesn't dissent, but it's a quasi-dissent. But the Chief Justice's judgment contains some very interesting obiter, which I will use as against others, because then we don't have to start with another case. But that doesn't mean I'm giving Chempakam any weight in terms of its power as a precedent. But we'll first do reservation, and then we'll come to equality, and we must finish reasonably quickly so that we can also talk a little bit about where do we go from here, the way forward. So let me start with reservation. And in a sense, it's a good segue into equality, because reservation is connected to caste and religion and so on. And at the same time, it is also essentially a question of equality, as it has been debated in the courts. Here, I will argue that maybe we'll start with a doctrine which I derived from Justice Gajendra Gadkar in M.R. Balaji, 1962. I'm trying to find these doctrines as early as possible, 50s or early 60s, because then we can test their power and how long they last as doctrine, even if they're not precedents, but as doctrines, they're very powerful. Justice Gajendra Gadkar says in M.R. Balaji, it appears that the Maharashtra government has decided to afford financial assistance and make monetary grants to students seeking higher education, where it is shown that the annual income of their families is below prescribed minimum. The said scheme is not before us, and we are not called upon to express any opinion on it. However, we may observe that if any state adopts such a measure, it may afford relief to and assist the advancement of the backward classes of the state, because, and this is the doctrine, because backwardness, social and educational. Backwardness, social and education is ultimately and primarily due to poverty. And in my own opinion, this completely subverts the purpose of reservation. And this is where it begins. And it's a doctrine that comes all the way through now to Janhit Abhiyan. The feeling that, look, that ultimately backwardness is due to poverty. That doctrine. Now, the history of reservation, as I may have said, begins in 1930 in the first Roundtable Conference as a constitutional idea. Of course, as a historical idea, it begins with Maharashtra, Shambhu Maharaj, and then Mysore and Travancore, and of course, very prominently Madras state. The 19th century agitations, non-Brahmin agitation, the Malayali Memorial, where the Nambudiri Brahmins and the Nayars demanded representation because the Tamil Brahmins, Tulu Brahmins, Telugu Brahmins were being given a huge dominance in the Travancore government. So the Nambudiri Brahmins and the Nayars came together and presented a Malayali memorial saying we want reservation basically in representation. Reservation is a concept we see in India demanding reservation in the Security Council of the United Nations. We want one seat reserved for us permanently. That's reservation. No one else can take that seat. So we have demands for setting aside seats for representation of all varieties. And based on this early history, Dr. Ambedkar takes this demand to the Roundtable Conference, and there he submits a memorandum on behalf of, detailed memorandum on behalf of the backward classes, where he sets down 8 safeguards for the backward classes, which he demands, constitutional safeguards. And as I said earlier, he had also said that the depressed classes want representative democracy. He had focused a lot on representation, not only responsible government, but also representative democracy. Of the 8 safeguards, number 4 and 5 have to do, oh, this should not be up there now, I'm sorry. Everybody is looking at the wrong thing. But I will put it up when, yeah, but there's no harm in putting it there. Yeah, but I just don't want to get distracted. So Dr. Ambedkar's safeguards number 4 and 5 are about representation. Safeguard number 4 is for representation in the legislature, and safeguard number 5 is representation in the executive and the judiciary. And safeguard number 4, Dr. Ambedkar says, in the legislature, I want separate electorates for the depressed classes. Now, why did he ask for that? Because due to demand from the privileged sections, number of groups already had separate electorates. Graduates of colleges, merchants, various communities. Muslims had separate electorates. So there were separate electorates for a number of groups. So Dr. Ambedkar said, give separate electorates also to the depressed classes, because I want a leadership to emerge from this group. Dr. Ambedkar did not say, as Mahatma Gandhi said, that I am here on behalf of all the people of India. He was not very happy that Ambedkar was there and others were there. I am the representative of India. But Dr. Ambedkar did not say that. He had one other representative from the depressed classes, and his main concern was to grow leaders in the depressed classes and not to become the only leader of the depressed class. So he said, I want separate electorates so that people will contest and emerge for 10 years. And then joint electorates, but I want reservation to make sure there's proportion, there's not for representation. This was his demand. And once Dr. Ambedkar, this was for the legislature. And of course, Mahatma Gandhi, who had no problem with separate electorates for various other constituencies, said not for depressed classes. And he was prepared to give up his life for that. And finally, Dr. Ambedkar had to agree, because he felt that if Gandhiji had died because of this issue, there would have been, it would have made the partition look like child's play compared to what would have happened in India against the Dalits and the scheduled castes. And presumably for that reason, he decided to compromise and get reservation in seats without separate electorates. And then, of course, Mr. Kanshiram wrote a book saying where he's called Chamcha Age. And he said that's where the Chamcha Age began, because from that point, it was clear that only what he called chamchas of the ruling class would be nominated as candidates from scheduled caste reserved constituencies. That does not mean that everyone who has contested from a scheduled caste constituency is a chamcha. That's just a Kanshiram point of view. There are many independent people who have come from there. But there was a problem about representation because the power to decide who would be the candidate was no longer in the community. They could just choose, vote for 2 or 3 people who were nominated by the dominant groups. So that was on legislature. On the executive and judiciary, the demand put forward by Dr. Ambedkar was a demand which did not use the word reservation, did not use the word backward. He said, he firstly proposed, I want public service commissions established constitutionally at the federal level and the state level. Then he said, I want regulation of recruitment into public employment so as to ensure the due and adequate representation of all communities. So no reservation word is not there. It was a word introduced by the Maharajas and others who had given provision for representation. They called it reservation. But Ambedkar never called it reservation. He called it representation through regulation of recruitment into public employment to ensure due and adequate representation of all communities, not backward classes, not backward castes, not backward communities, just communities, all communities, including the oligarchic or privileged communities. All communities are entitled to have due and adequate representation in the judiciary and the executive. So the scheme that he envisaged was that there would be a continuous monitoring. It was not time-bound. It's not time-bound. It's not time-bound in the Constitution. There is a big myth that reservation is only for 10 years for jobs and education, and after that it is to expire. That was only for the legislature. The reservation in the legislature was for a time-bound period because there was a feeling that democracy would kick in automatically, the majority of people would be represented, and that was like a test of how well is democracy working. And it hasn't worked well, so there's still almost no scheduled caste or scheduled tribe outside the reserved constituencies. And so it hasn't worked as expected. As I said, democracy has failed. We still have elections, but we are, according to a number of international sources, independent sources, we are no longer a democracy. So it hasn't worked. But for jobs and education, it was not intended to be time-bound. It was intended to be a permanent mechanism where there would be constant review of representation and the adjustment of recruitment so that those who are overrepresented, you slow down on their recruitment. Those who are underrepresented, you increase their representation as needed constantly. That would be the job of the Public Service Commission. And this is relevant to the subclassification judgment. It was for every community, not a group of communities, not a block. So the demand that many of us have been making is that there should be a targeted an indicator for representation for every community so that they can make a claim. We have to have 2 positions or 0.5%. And if we, as I said, if you take the Supreme Court and apply the Ambedkar principle, you get what I described to you yesterday, which I will not repeat. But that's not a quota. That's not a rigid quota. That's just an indicator of is there healthy representation? And who is not represented at all and who is overrepresented. So this was the approach to representation. There was no backwardness in it, just as India's demand for reservation of a seat in the Security Council is not linked to India's poverty or India's backwardness. Let's say India becomes the world's most prosperous country. Will we say, okay, fine, now we don't need a seat in the Security Council? Are people trying to uplift India by giving us a seat in the Security Council? They want India's, we are saying India is the most populous now, the most populous country in the world. Our voice must be heard in the Security Council. Whether we are rich or poor, educated or uneducated, literate or illiterate, not relevant. Can the United Nations tell us, fine, we'll give you representation, but no creamy layer? Send only your poorest tribal woman as your ambassador. I'm sure she'll do a much better job than the current ambassadors. If you do that, it'll be a good idea. I'm not going to get sidetracked for lack of time, but I'm sure that'd be a great idea. But if the United Nations said that, what would we say? We will decide who will represent us, not you. Maybe creamy layer, may not be creamy layer. That's our problem, right? But we want reservation in the Security Council, regardless of backwardness, illiteracy, poverty. We don't want any creamy layer because we want representation. We want a seat at the table. That's what Ambedkar demanded, a seat at the table for everyone, right? Now, seat at the table for everyone means that the representation on the Supreme Court, if you apply the Ambedkar formula of the dominant classes, of the oligarchy classes would be reduced from maybe 30 out of, it's always shifting, but maybe 30 out of 34 to 1. But more than that, they actually believe this is very dangerous because you and I, some of you and I may be excited about the idea of an illiterate tribal woman being India's ambassador to the United Nations and sitting in the Security Council and speaking, right? But not everyone will be excited by that. And they will genuinely think that this is going to really be dangerous. Now, there's a book on written by Malavika's University of Michigan professor, one of the professors on elitism, a very detailed book. And there he says that when France and the United States achieved, they overthrew their colonial and monarchical rule, they were confronted with a question. Do we retain elitism? Elitism is the belief that some people are superior to other people. We don't know why. It may be nature, it may be nurture, but there is an inherent inborn difference in ability of people. And we want only the elite to rule us. The difficulty with feudalism and aristocracy was that you thought that the elites were only aristocrats born into rich families. Like here, we say that those who are born into these three communities are inherently, must be, there's a default presumption in their favor that they must be capable, rebuttable presumption. So what the Americans and the French did was to reject that proposition. We will no longer accept the proposition that the superior people come only from a certain class. We know that they exist in all classes. We sometimes see people doing manual work, maybe 4 people, but we can see one of them is doing it in an extraordinary way. He's extraordinary. So they may be women, they may be of different races, colors, they may be of different classes, but there are extraordinarily talented people in all parts of society. And so they said their challenge was to find these extraordinary people, bring them together, and construct an elite from them. That's what they mean by affirmative action. It's not about representation. That's why I don't use the word affirmative action when I decide, because here, rather than reservation, I use the word representation. Article 16.4 is about representation. Reservation is only a tool, but it's a provision not for reservation, it's a provision for representation. But they call it affirmative action because they want to find out. So they have all kinds of programs to identify who these talented people are. So they started using standardized testing, all kinds of investigative tools to identify these brilliant people and then bring them together into elite institutions and make them an elite, and they will rule, and they will rule. Now, so they try to democratize the sourcing of the elite, but elitism is an anti-democratic idea. And that's partly behind Trump's rise in America, because a lot of average Americans reject this idea. This is an idea of the American elite that took over after the revolution. But average Americans are not impressed by people who have fancy degrees from fancy places and are very clever. They're quite suspicious of them. And so their idea of democracy is represented by a Norman Rockwell painting where a carpenter wearing his carpentry outfit and holding carpentry tools is addressing the local assembly, the local legislative body, and they're listening to him. Because that is their idea of democracy, is that the common people must hold power, not the elite, right? So there is a tension in America between the American elite who believe in elitism, and maybe the same in France, but I'm not familiar with that, between the common people in France and the elite there. I'm not aware of that. But certainly in the US, there is this elite, tussle. So for us also, we also very much think the caste system is a system of regulating, identifying, classifying, and regulating the relationship between communities. But it is also very much based on the belief, as we know, as Dr. Ambedkar told us, that there is a graded inequality. Some communities, not individuals, but some communities are superior to others, are wholly populated by people because of their Purva Janma Karma Phala, wholly populated by clever people. And so they must form the elite. So there is then elitism, which Dr. Ambedkar actually was against, and he wanted to break it down. So that's why he's a representation of all communities. And this is deontological, which means it is not utilitarian. It's an end in itself. It's part of Swaraj. We want to rule ourselves. And that was the objective behind representation, reservation. But that was because of the concern of those who believe that superior people must rule, elites must rule. There was a concerted hostility on the part of the bureaucracy and the judiciary towards this idea that there will be representation in the judiciary and the executive. You go to the legislature and even there they talk about you must bring in property qualifications or degree education qualifications, but they know it's hard. But they certainly want to preserve the judiciary and the executive branch to ensure that only the elite rule there. And when there was representation in these two areas, there's strong hostility against it. And what was their strategy to oppose reservation? This was the strategy. This was the doctrine that they used. They redefined the whole concept of reservation. They took that the reservation as something that they wanted to get rid of, but had to deal with. They didn't like it, but they converted it into an issue of backwardness and primarily due to poverty. From that comes these doctrines of creamy layer exclusion, because if you're no longer poor, you're no longer backward. It comes from how long will it stay? Some community, it's like saying India's GDP is growing, so no need of representation in the Security Council anymore. So, India's become powerful. Why does it need a permanent seat in the Security Council, right? So all these, now as a result, 12, and this is the last thing I'll say and then move on, 12 sub-doctrines or doctrines have been enunciated by the judiciary extra-constitutionally to block the representative purpose of reservations. And therefore, reservations did not grow. And one was to, and I'll go through them very quickly, the 12 purposes. I think I'll, at this point, okay. So these are the 12 doctrines to block reservations. This is the doctrine. Backwardness, social and educational, is ultimately and primarily due to poverty. As a result of that, so the first point I've already said, the court has delinked reservations from its central purpose, which is representative democracy. And you see that as a consistent string through all the major decisions on reservation. The one exception, the only judgment, and I'm not saying this because he's present here, which acknowledges that the purpose of Article 16, if not 14, is representation, is Justice Bhatt's judgment in Janhit Abhiyan. So at least there is one sort of recognition of this original purpose of Dr. Ambedkar in that judgment, but otherwise there is a consistent view supporting the Gajendra Gadkar doctrine. The second is the court has rejected. Is it clear, or should I make it a little bit bigger? Okay. The court has oh, yeah. I use Excel to do my writing, actually, because it's much easier to use than Pages or Microsoft Word and all that, yeah. So that's why it's a little funny, but it's very flexible. It's a great, it's for accounting, so it's got to be very good, because they make good stuff. The court has rejected the most fundamental principle of representative democracy. That is, the court has rejected the most fundamental principle of representative democracy demanded by Dr. Ambedkar, that representation must be in accordance with population share. That they have consciously and clearly rejected. That's again a judicial doctrine that damages democracy. The narrative of economic reasons for backwardness disconnects reservation from democracy. The rejection of population share also it damages the democratic objectives of reservation. The court has damaged the link between reservations and representative democracy by upholding reservation for socially and educationally forward communities, subject to a creamy layer cutoff, which is EWS, thus endorsing reservation for the overrepresented, simply because they happen to be financially disadvantaged, not even economically disadvantaged, right? Now, we are here, we heard in Champagam Durarajan an argument that about 46, and in other case that 46 justifies reservation in some of the early judgments. But when it came to Janhit Abhiyan, 46 was used, like Champakam used 15 to protect the Brahmins, 46 was used to exclude scheduled castes and scheduled tribes. Flipping 46. 46 says this is for economically weaker sections, especially scheduled castes and scheduled tribes. And Parliament in its objectives resolution says EWS is to implement 46, and they excluded scheduled castes and scheduled tribes from that. So another instance of a democratic provision being flipped on its head. The court has expressed the need to end reservations for jobs and education without any basis. This has intensified recently. How long will this last? This cannot go on. It is time bound. You'll be very surprised how the Supreme Court erroneously repeats this erroneous assertion that reservation in jobs and education is time bound. It's not, but they repeat it. They call it caste-based reservation, although it's actually for backward classes. The scheduled castes also, if you look at the definition of scheduled castes, tribes are entitled to be included in scheduled castes. Groups are entitled to be included in scheduled castes. 6, the Supreme Court has another doctrine, another second doctrine on reservations, which is that reservations damages merit. One is that it is an exception to equality. That, I think, has been rejected quite firmly. So I'm not putting it as a doctrine. But the idea that reservation affects merit is a wrong idea. Merit is irrelevant to the idea of reservation. Is still, I think maybe I'll say it here, is still strong. What I was going to say is that there was an interesting intervention by Sardar Patel in 1949 in the Constituent Assembly. Early on, in response, as a compromise with Dr. Ambedkar, it was agreed that minorities would get representation, not just scheduled caste and scheduled tribe, but also Muslims would get reservation in the legislature and in jobs and in education. And this was approved by the Constituent Assembly. But after the partition in 1949, an amendment was moved to the agreed draft to drop minorities so Sardar Patel said for minorities, but the largest minority, there were two largest minorities, SC, ST and Muslims, they will get, but the provision to give reservations to minority was amended and taken out. On the basis, I would assume, that after partition, 65% of the Muslims had left. And so why should they have representation? Maybe that's the argument. But anyway, it was amended and removed. And the a Sikh member of the assembly, if I remember his name correctly, it was Hukum Singh. He made a long speech saying, this is a betrayal. We've already agreed on this. You cannot reopen this. So the presiding member, maybe the president or the presiding member, put it to vote. Can we reopen this? And they all voted saying, yes, we can reopen it. So that was the end of that objection. And then they discussed it, and then he spoke. Dr. Ambedkar did not open his mouth, according to the record. He didn't say anything. He moved the amendment and sat down. He probably told Sardar Patel, this is my imagination, that you're piloting this, you speak. So Sardar Patel himself comes in 49 to the assembly and explains this. And he says that this happened. I met with Sikh. Now, Sikh member is speaking, but I met with the leading Sikhs. Here is a document I signed with them. They've agreed that they don't want reservations in legislature or executive or judiciary, except if they come into backward classes. But other than that, they don't want, as for minorities, they don't want reservation. They've agreed to all that. So he was quite angry. Why are you calling it a betrayal? I talked to all these people, you agreed, we admire you for that, and so on. Then he says, in any case, if you want it so much, I'll give it to you. But why do you want it? This is only reservation for chaprasis, he says. Why do you want it? So the intention was clear. It would not be for foreign secretary or home secretary or finance secretary. It would only be for chaprasis, where a social reservation already exists. It's almost 100% reserved. Now, with the struggle, it's crept up to initial appointments and promotions for SC, ST, not for OBC. So there's a constant push to push it up. So they knew very well what they were doing. They would not have representation at the top. They've introduced it for the district judiciary, but not for the high courts or the Supreme Court, again at the state level. So it was very clear that merit would be compromised by representation, not reservation, by representation. They don't have the guts to say this openly. They say reservation will compromise merit. What they really mean is representation will compromise merit, because we'll bring people in who really have no merit as human beings. So that's the other doctrine. The next doctrine is the court has they put a limit, 50% limit, which Justice sitting in this city, Justice Jennifer Reddy, in his book, Constitution and the Courts, Summits and Shallows, he says it's unconstitutional. But there is a misrepresentation of Dr. Ambedkar saying that 50% should be open, because Dr. Ambedkar had in mind that this situation of regulation of recruitment for public employment, where he said as a normal matter, 50%, the adjustment should take place within 50% normally, and 50% should be open. But he did not think that 50% should be kept to protect over-representation. That was not his intention. So initial period, there would have had to be 100% reservation to bring it down, so that lots of unrepresented communities would get a look in, to use his words. But once it settles down, then roughly we should try to ensure that at least only half is used to make this regulation, and not more than that, so that others can also, there's a variety to come in. Because at the end of the day, there would also be, like Dr. Ambedkar agreed to 10 years for reservation in the Legislative Assembly, because he thought that in 10 years, there would be a change in society. So there would be a change in society, and 50% would be, it was also an assurance to get support for reservation to the Constituent Assembly, to the dominant people there, that look, we'll at least keep 50% open for you. But it should not be interpreted by, as Dr. Ambedkar saying, that you should give reservation to the overrepresented, or this 50% should be used to continue oligarchy or overrepresentation. Oligarchy is Dr. Ambedkar's word, not my word. The court has narrowed the scope of reservations by restricting reservations to only initial appointments and not promotions. I've already covered that. the court has imposed a prerequisite for instituting reservation. There must be data showing backwardness and inadequacy of representation. Fair enough. But the court also says they will not order the government to do a census. And the government is the only one that can produce data that the court can accept. So if you say you must have data, then you must order the government, and the government refuses to produce data, then you're basically saying you can't have reservations, right? You must, you must have a uniform to get into this room, but I am the only one who has that uniform, and I won't give it to you. So it's like saying you will not enter this room. That's all. So then we have subclassification, which has all its problems. I'm not getting into it deeply. I'm simply saying that the experience with subcategorization in OBCs, I know from direct experience, has not resulted in the most marginalized groups getting representation. That is a problem. I agree that all groups must have representation. That is a problem. But if you look at the experience in OBC, by putting a very weak marginalized community from category A to category B, they're not going to get representation, because in that category, there will be stronger groups. They will get most of it. The only solution is that every community must have an indicative, targeted, earmarked share. That will ensure they'll get it. It doesn't matter whether you're in A, B, or C, or D category. And that's the experience from the OBC reservation. So it's not going to solve anything, but it's going to create conflict, internal conflict, which is, I think, probably the political aim. And also the political aim is to give some hope to the smallest communities that you will get something in return for getting their electoral votes and support, which of course will dissipate when they find that they don't actually get it. So they're playing politics with it. Actually, the judgment written by Justice Santosh Hegde and Justice S.B. Sinha in E.V. Chinnaya are excellent judgments, And Justice Santosh Hegde actually, in a mild way, raises this political question issue. And he says, look, basically, this is the constitutional scheme. Further categorization, he implicitly says, go back to Parliament and amend the Constitution. But don't come here to get this through. So he treats the question of subclassification not as unconstitutional or against a basic structure, but he says, look, this is not the way for a state government to subcategorize a category like scheduled castes, which is a single category, right? Only the President of India can initially include, the initial list comes from the president, and all subsequent inclusions and exclusions are approved by Parliament. So how can a state tinker with the list? So he says, even if it's the same list and you just move them around into different groups, you're creating sub-classifications and giving them different entitlements. And whether that is what the Constitution wants is a question for Parliament to decide, right? So it's a political question. And the other thing I think is a very big issue for me is that there has been a lot of abuse of this OBC category. Lot of communities that really don't deserve to be there are there, because the original intention was that that representation has been denied to communities which have been treated as untouchable in one form or the other. The intensities of untouchability and practices vary, but that is the group that requires representation. Some of them were included in the scheduled caste list. Tribes which were equally excluded are included in a scheduled tribe list, and other communities that suffered more complex arrangements of untouchability were to be identified as backward classes and then to be also given representation. That was really the main idea. But today we have Brahmins in the OBC list, Kshatriyas in the OBC list, Vaishyas in the OBC list, Shudras in the OBC list. Right? All of them have come in. We have, and many of the Shudra communities also are very powerful communities. And so then the 27% share of the others who have suffered from or been victims historically of untouchability has shrunk. So that's another way in which the dominant groups have kind of hijacked the representation, not reservation, from those who need it the most. So these are the main points I want to make on representation. These are the doctrines on the issue of reservation, which to me is an issue of representation. It's only a tool. I always say, if we get a better tool for representation than reservation, we will discard reservations. We'll throw it away. We don't want it. We have no interest in reservations. Our interest is in representation. And there is, in the United States, there is a system for giving economic representation in the economy of the country to minorities. And it's ironical that Indian elites go to the US and claim that they're minorities and claim this benefit. That is, many government, state and national government agencies are mandated to give as much as 25 or 30% of their contracts to minority-owned or minority-led companies. Right? This is done in a number of countries, but we won't do it. Why? Why can't we say that 25 or 30% of the budget of the union government and all state governments must be given to companies which are owned or led by scheduled castes or scheduled tribes, or these untouchable victims of untouchability backward classes? The United States does it. And that's the way in which that's the way they bring people into democratize the economy, give a share to everyone, and not just the opportunity to be servants of a small class that monopolizes these opportunities. After all, government funds are raised through public taxes. So that's done. So let's now move to the last part, which is equality, because we are at 5:30. On equality, I want to start actually with this sentence from C.J. Rajamannar in Chempakam, Madras High Court judgment, which to me reflects a doctrine that is very widely shared, not only in the judiciary, but amongst the bar, not only in the bar, but as a doctrine that comes from the axiology, the dominant axiology. It is this: one cannot shut one's eyes to the fact that inequality is a fundamental or basic fact in actual life, writes the Chief Justice of the Madras High Court. Absolute equality there is not among humans. I've had hundreds of lawyers, judges, law teachers, especially in the North, put their palm out to me like this when I talk of equality. Professor, ye 5 ungli dekho. Sab ek size hai kya? Equal hai kya? There is no equality. So the doctrine of the judiciary, the real doctrine guiding the judiciary on equality is, there is no equality. People are not equal. They confuse equality with differences. They don't realize that we need equality because there are differences. If there was no equality, there would be sameness. If there were no differences, there would be sameness. Then we don't need equality. But we need equality because there are differences. But equality is a real thing. It is a real value. It exists as a value, as a concept. It is a recognition that for all purposes, all human beings shall be counted with the same value. When it comes to your opinion as a human being, as a fellow human being, regardless of your age, gender, education, class, whatever it is, your opinion will not count more than anyone else's opinion. It is a commitment to that principle that we call equality. But for that, you need an axiology, a system of creating value that will recognize that somehow, where does this equal value derive from? So for the Abrahamic religions, Islam, Christianity derives from the belief that all humans are children of God, a religious belief. It comes from Narayana Guru in the belief that we are all born in the same Janma Riti. It comes from Dr. Ambedkar, from his scientific understanding that we are all members of one species, and his personal knowledge that even the people at the bottom of the pyramid where he once was have equal value as the people at the top of the pyramid where he ended up. But this axiology from which the judiciary is now drawing its doctrines and its values deeply believes that there is no such thing as equality. So then what do you do? Then the problem for the judiciary becomes, and Article 15 was written from Dr. Ambedkar's axiology, not from the judiciary's axiology. Equal protection of the law and equality before the law from the Irish Constitution, equal protection of the law from the American Constitution. The axiology of these phrases, Dr. Ambedkar consciously took from a belief in the substantive existence of equality between all human beings. But it was then handed over to be worked to a bunch of people whose axiology rejects the idea of equality, who believe that there are 4 types of births, men and women are different, and there is no equality. As Justice Rajamannar says, there is no such thing. I'm very grateful to him for being so honest and writing a judgment that there is no equality. But this is what people, most people many people in the oligarchy actually believe. They may not be so honest to, as a judge, to say it. So then the judiciary's problem becomes, how do we treat unequals to comply with the requirement of equal protection of the law and equality before the law? Then classification becomes important. So Rajamannar goes on to say, later, I think he says, the power to govern men and things is inherent in every state, and it involves classification, differentiation, and abridgment of individual freedom. This is how we deal with a bunch of unequal human beings. We have to classify, we have to differentiate based on, are you superior, are you inferior? And that comes from which group you're a member of. If you're a woman, you're inferior. If you're in this community, you're inferior. So I have to take all that into account and differentiate between you. And then abridge your freedom as necessary. Because you may want to be an aerospace engineer, but you really don't have the, God didn't make you for that. God made you for something else, to be a manual scavenger. Right? So your freedom has to be abridged. You cannot study. You have to work. And so Rajamannar says that some which bear a reason. So what do we do? The classification or differentiation of citizens in the exercise of this power must always rest upon some difference which bears a reasonable and just relation to the act in respect of which the classification is proposed, and can never be made arbitrarily and without any such basis. So it must be justified. Now, this is also shared with international approaches to equality, with American approaches to equality, but they rest on a different axiology. They also deal with the same issues of, if we classify, if we differentiate, we have to do so reasonably, we have to be fair about it, right? But their approach to the issue of equality starts from an axiology where you give the same value to every human being. Whereas here we are starting from the axiology that two human beings don't have the same value because they are put in groups and groups have different values. And therefore, we are not able to move towards equality. All of us, women, others, who battle for equality, we know that we are making no progress really to equality. Even industrial countries are suffering from lack of equality, but we are way behind. The hierarchy in all parts of the state, the fine hierarchies that exist, constant inequality, because we have a worldview that says that human beings are not equal. So this is the doctrine on equality, which I think has said these doctrines are what Adam Smith might call sort of the unseen hand, right? That is operating behind a lot of decisions and judgments, right? So that's on. That's really the main points I wanted to make on equality, just to leave the fundamental thought with you that this is the problem in our approach to equality. There's a lot of detail to be thought through and discussed, but the problem is we have to. So my point again is the judiciary must reach out to alternate axiologies like that of Dr. Ambedkar, Phule, Narayana Guru, so many others who accept, embrace the idea, know that all human beings are the same, are valued. We are not the same, that we have equal value because we have differences. So equality is a counterintuitive mindset that sees so many differences and reminds us that actually we all have the same value. We may be different, but we have the same value. So it's a counterintuitive understanding of value. And unless we reach to an axiology that approaches the value of human beings the same way, our jurisprudence on equality will not be able to move forward. So these doctrines on equality have again been very damaging to democracy. So let me stop here on equality. I have other issues I had shown to you, so I'm not going to repeat them, but I think we'll have to stop here and maybe take it forward. But my main purpose was to introduce to you another way of understanding the relationship between constitution, courts, and democracy, and in light of the fact that we are today not a democracy, we've lost our democracy. So on the going forward, all I would say is to say that first of all, we must recognize that our democracy is lost. If we can't even speak carefully, can't go on social media carefully without worrying about being arrested and thrown in jail, we are not in a democracy. So then the question becomes, how do we regain that democracy? Because we cannot move forward without democracy, according to me. That's a debatable proposition, but I believe in that. We can debate that. And if we want democracy, what should we do about it? So what we can do is to there are many, as I said earlier, there are many doctrines of the judiciary which are supportive of democracy. But there are many doctrines which are very damaging and weakening to democracy. And so our job inside the system, the legal system, is to identify those doctrines which are weakening democracy and correct them and ensure that, and we can't do it simply by looking at the front end of precedents and decisions. We have to go to the back end. As I put up the slide I put out in the morning, we have to go to the back end, understanding what is the doctrine that somebody is following and what is the axiology from which the doctrine is drawing its values, its process evaluation and set of values, and then to make sure that they get aligned with democracy and democratic values, and then we'll be able to correct the areas where there are weaknesses, so that we want to be in a situation where at least we can say that the legal system is not only not weakening democracy, but is actually strengthening democracy. So we can, and I think the way forward is for us to, frankly, to research more on this, identify the areas where our doctrines and rules and principles set out by the judiciary are actually damaging democracy, surfacing them, and building counter arguments to ensure that those are corrected and aligned towards democracy. Let me stop here and we can have some questions, and then after that we can end with your permission, Suhasini.
Thank you, Professor.
Yes.
Another thought-provoking lecture. I would want to know your views on, we are looking at judicial precedents to understand how these have democracy weakening features. But it is from your lecture that I am also thinking that what is the axiology from which democracy is drawing its value? Because that also has different theoretical foundations. And depending on time, space, temporality, we know democracy as a value has been historically quite compatible with the concept of merit, unequal citizenship when we look at Athenian democracy. Historically, we know the relationship between mercantile class, capitalism, and democracy. We also know the relationship between equal citizenship, right to vote, and democracy. So if we are, and from that I'm trying to think, are we looking at democracy as a value because they are multiple, or are we looking at these values of equality, fraternity, liberty to tell us that this is what our democracy should look like? Because the philosophy, axiology of democracy also can be indicted just as the same way as secularism can be indicted depending on where you place it.
Very, very good and an important point. I would say at the very beginning, I identified the problem of what is democracy, demos and kratos, power in the hands of the people. I identified it with Swaraj in the freedom struggle, the concept which actually predates Gandhi, the idea of Swaraj. It's a very important idea that is present in all people's movements all across the world. They want self-government. And why Swaraj? Why democracy? Why should power be in the hands of people? Because the process of forming values, of value, determining value and attributing value, should be done by people. So we are not saying democracy is a value. Democracy is the right process through which we establish value. So we can either get the elites to determine value, or we can have a process. Now, the problem with the Athenian democracy was that it was not inclusive, but it was certainly better than many other parallel situations where you could only decide if you were born into a particular group or family, right? Or you're born into a king's family or so on, right? So here, the problem was it was not inclusive, and it should be. But what we now say, what we are now conceiving of is a democracy that is completely inclusive, and where every human being has a right to determine value. That's ultimately, I think, the most important power in society, political power in society, is to decide what is valuable and what's not. And that certainly should not be left to an elite. So we'll have to look at the axiological process itself. So that's why I'm looking at axiologies which have been put together from people who have emerged from popular movements. non-elites, who are themselves non-elites, who are reflecting the aspirations. I don't think we should make elite or non-elite a criteria, but that's why I'm saying there are multiple axiologies we should look at. I'm not saying replace this dominant axiology with another axiology. This dominant axiology, frankly, also has its value. There are a number of good ideas in it, number of values that it has which everyone may accept, right? The problem is it should not have a monopoly. So it should compete with other axiologies. Basically, this is the main message of Narayana Guru is this. He says, every human being should study every other axiology, every other religion, and learn what is good in it and reject what you don't like. And from that, an axiology should develop, a democratic idea and a process for every generation, not to bind future generations, that will have the freedom. I want to have a voice in deciding what is valued in my world, in my society. Why should I not be consulted? So that's the direction, I think, in which so as I said yesterday, ultimately democracy is about facilitating a conversation between equals. So equality, fraternity, liberty, dignity are all facilitators for a conversation. What will emerge from that conversation is uncertain. But without these four attributes, you cannot have a conversation. Yes, sir. Yes, sir.
Yeah, okay, this works. Thanks, Professor Gopal, for an extremely stimulating talk. I've attended all the 3 sessions, and there's so much food for thought. As I explained to you a few hours ago, I'm not really a legal person. I'm a sociologist, anthropologist. I'm a social scientist, sociologist, anthropologist. So minus the legalese, I'm looking at other kinds of dimensions here. And one of the things that I think has been constantly running through your talk is this tension between the normative and what is actually the case. The tension between the normative and what is actually the case.
Yes.
So again, lots of important things you said, but 2 things that I think I want to, maybe you could say something more about them. So you draw this contrast between democracy, VDEM, all of this, which has now gone wrong.
We've lost it.
So where was the pure form?
We are an autocracy. Yeah.
Right. And then, so for me, the question is that, are we talking about Nehru's India? Are we talking, you clearly do talk about the independence movement. Because then how do we, for instance, fit the fact that Nehru's India is heavily centralized? And
Nehru's India
is heavily centralized.
No, we don't want to go back to Nehru's India. That was also elitist. We want to move forward. As Kamala Harris and her campaign are saying, we're not going back. We are going forward.
Okay, so I mean,
and we have a framework, the Constitution, which is also a result of political compromise. But what is very precious about this Constitution is that it has a very strong arsenal for taking us towards a democracy. We are on the runway. Our taxiing has been blocked. We just need to keep taxiing and take off. But we have an arsenal. The American Constitution started out as a racist, patriarchal, misogynistic, document. But that potential was utilized through amendments and through various struggles to build a much stronger democracy than anyone had anticipated. That's why I, in the first day, defined Constitution as a site of struggle. It's a site of struggle. But we are very lucky in this country that the Constitution has some imperfect provisions that enable us to win back our democracy. So Constitution has not lost its democratic potential. Those who work the Constitution have defeated its democratic potential. But that democratic potential may be amended and taken out, but it's still there. And for us, we have to use it.
I think this also connects with the other question I had, which is that, and of course, personal logic, etc. You haven't said much about the mechanisms through which these judges have acted. The Constitution, etc. is fine, but how is it that we are seeing these regularities? How is it that...
I must say that in these interventions, I'm not, see, there is a practical side and the back end, right? The practical side is judges get cases, lawyers, clients go to lawyers, they prepare briefs, they decide what issues to frame, what facts to put forward. That comes before judges. They decide, they have to decide, they have to work within the relief, the framework of the relief that is sought, the facts that are placed, the arguments that are made, the pleadings. That all goes on. But what we are interested in now is the back end of that. That there are certain, and in doing that, they deal with lots of ideas, lots of laws, lots of precedents, lots of principles, lots of sociological facts. It's a very complex world. But I want to focus, because we have lost our democracy, I only want to focus on some doctrines, very important doctrines that are influencing this practical process in uncertain ways, but certainly a big influence in, not certainly predictable, logical, linear, that they will decide like this or decide like that, but it's a big influence. Some judges resist it, some judges don't resist it, some have their own way of doing, but it's a big influence. So unless we tackle these doctrines and delegitimize them, then they no longer be an influence on the judging process. So it's that back end I'm looking at. And behind the doctrines are a set of an axiology, which also, as you said, has to be interrogated. And we want to democratize that process so that we are not trying to replace the current axiology with my own axiology. We want to replace it with a process that will produce a constant stream of democratic values that will feed that axiology. So that's a back end which I, as someone who's worked with the judicial system and with legal education for many decades now, at the back end, I work at the back end. I see there's a lot going on in the back end, which a lot of these, like when a bus driver drives, he doesn't know physics. He doesn't know how this machine works. He doesn't know how anything works. He says, look, I want to get from place A to place B as quickly as possible. Don't tell me anything else. I need to move the gear. But behind all that is a physics. I'm focusing on the physics and saying, what is the physics that is driving this? And this driver is going off in the wrong direction. So can we do something so that these cars, not just looking at driver A, B, or C, but can we redesign the cars and make them safer? When I was in law school in the 70s in the US, I had the privilege of listening to two people, and I often think of this house, how idiotic I was not to realize who they really were. One was Ralph Nader, right? A man who actually, used law to redesign the entire way in which we think about safety, right? And what he told us that day, because there's a lot of students here, I want to share that with you. He said, look, when I was a student there at Harvard Law School, he said, I came and I asked a senior professor one day, Professor, why is there no course here on food and the law? And the professor, he said, laughed at me and said, what is the connection between food and the law? There's no connection between food and the law. What kind of silly question are you asking me? That was Ralph Nader. He made sure that there is now courses on food and law in all law schools in the world, right? The other person I happened to hear, and I didn't realize who he was, and he left, he said something I couldn't appreciate, was John Rawls. He came to talk to us. And someone asked him a question on postmodernism, and he said, what's that? There's no such thing as postmodernism. Then I said, look, he's got a closed mind. But I didn't realize, that he was one of the most important philosophers of legal philosophers that we have. So what I want to say is there's a lot going on in the back end. And we have to redesign the way this ship is working. And there are many things to redesign, but one of the issues I've experienced in my work as a problem is this unseen influence operating in the heads of lawyers, judges, simply because they're all being drawn from this Veda-based axiology, which is basically stuck in the 3rd or 4th century BC. There's nothing wrong with, there are still some good ideas in it, but that's not enough for us to move forward. So and some of those doctrines are weakening, seriously weakening democracy. So we need to fix that. So that's where I'm coming from, actually. But the work will go on. Judges will decide whatever they have to decide. Yes, ma'am. Yeah.
No, what I wanted to know from you,
Yes.
Because of, in a way, the stress you have put on both doctrine as well as on the back-end work. And I suppose many of us who are teachers and as well, I mean, as teachers and students, let's say learners in the whole process, be participating in that back end, in several sorts of ways, and largely in a very unquestioning manner.
Yes, very right.
So what would you like from both your experiences as an educator, as well as somebody who's worked with the judiciary and has looked at the system there, how would you want to alter the way we learn law? Because I mean, at least one of the things I just wanted to add this in before one of the things I felt as I was listening to you, you're calling it doctrine, but what was going in my head was there's a lot of chants, as law people, we just say them. The chant in relation to classification, the chant in relation to that, unequals can't be treated equally.
Yes.
And just when I heard you now, it's like how unquestioning we are on the fact of that actually we are not accepting equality and hence all of this is coming.
Equality.
So much of classification, which we teach all the time, is taught in this very unquestioning kind of manner. So if I was to ask you that, Professor Mohan Gopal, how should we alter the teaching of constitutional law or interpretation, or what do we fix at that back end that things alter?
A very, very, very tough question. A very difficult question. But incidentally, when you were speaking, I was realizing I taught for 9 years as an adjunct professor at Georgetown. I worked in the US, studied there. I have never heard this phrase outside India. I worked in other countries. Unequals should not be treated equally. Never heard this phrase, because they are dealing with equals. The question is, how do you treat equals equally? Because everyone is equal. The differences don't make people, a difference of wealth and power, they don't make people unequal. Their wealth may be unequal, their knowledge may be unequal, but they're not unequal as people. So there's a strong assertion in other societies of the equality of people and inequality of circumstances. But we reject that idea. We believe that there is no equality amongst human beings, and we confuse, as I said, differences for equality. Whereas differences, equality, as I said, is a counter to the idea of differences. So no, I think we should put classification in its place. But basically we have to understand that we are dealing with the question of how to treat equals equally. There's no other question before us. There's equal human beings have to be treated equally. Because of their circumstances, some are treated unequally because they are women, but they're all equal. So then we focus on how do we alter the circumstances. So then the classification becomes different. We are focusing on, as Justice Thurgood Marshall says, focus on the evil you're trying to suppress, right? Now, the classification doesn't include that normative question at all. We're just looking at the object of the law. It's almost like you're standing apart from the legislative and the executive act and saying, is there a law that is lawful? And you're assuming that that law will only do good things, right? And then it's a classification based on differential criteria. Is there a nexus between the classification and the object? Very mechanistic, but you're completely stepping back from the question of what is that's why you end up with these results. You're stepping back from the question, what is the evil or that this law is trying to suppress? And and what is the solution for that? And if classification is a way of dealing with that, of dealing with that evil, that question, we can use that as a tool. There's nothing wrong with it. But I think classification as we have changed the right to equality, the right to be classified. Yes, 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 yes. Yes, 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 yes. Because we are sidestepping, not sidestepping. We think there is no equality, so there's nothing more to do. Yes, exactly, exactly, exactly. Because our problem is, how do you comply with the legal requirement of equality before the law and equal protection of the law for unequal people? That's our problem. And classification helps us to do that. And we must find out some justifiable way of giving equal protection of the law and equality before the law to unequal people. Like between let's say you had slaves and masters, and you had an obligation to give them equal protection of the law and equality before the law, right? But they're slaves and masters. We'd say, okay, how do we ensure that this is complied with? But we know slaves and masters are not equal, because not equal as human beings, not just their status, but as human beings, they're different. One is inferior human being, the other is a superior model of the human being, like Suzuki 800, which I used to have, and then Baleno or some fancy Suzuki. So they can't be equal, right? So how do you treat them equally under the law? So that's the problem. But on teaching, I would say that the first step, ma'am, was what you've been doing, and very well, and Professor Bakshi and others have been doing, is really to produce more writing and books about it. Because ultimately, I find when writing or speaking now, not just, when you produce material, then teachers and students pick that up. And that's a good way. So to do our work of theorizing and so on. And the other thing I would say is, from my limited experience, of also putting these arguments appropriately within the context of particular litigation and issues, also before courts, and assisting in that process on behalf of marginalized sections, because you want to bring a new axiology to the attention of the courts, which can be done through books. Books are influential on courts. Lots of books get acknowledged more and more by judges, by teachers, students. So I think we need, this is where I used to differ with my teacher, Professor Menon, who I love and respect very much. But my feeling is, in our Indian legal education, our big crisis is we are not teaching theory. We are giving too much of emphasis to clinical education, practice. Yeah. Yes. Yes, yes. Classroom, for which we need subjects like jurisprudence, like legal theory, Yes. Yeah, because now what I've been very happy to find is that all these we are only talking theory and concept. I thought they'll all leave in like 10 minutes, but they haven't, right? So they're also theoreticians. They like theory. They like to hear about theory. Theory is basically, the theory means what you see. It comes from the Greek Latin word thein. It means to see. And the theory is something that explains something and predicts something. So theory of gravity would, if I drop this, it drops. It doesn't fly up. So the theory of gravity explains why it goes down and not up. And it will predict that if I leave it, it's not going to stay here. I'm not on the space station. It's going to go down, right? So that's what theory is. Theory must explain something. So I'm trying to explain why democracy has been lost by us. I'm trying to explain that one of the important reasons why we've lost democracy is that certain doctrines have been developed by the judiciary, and those doctrines have actually facilitated the growth of an extreme radical movement that is really overthrowing democracy. And the identities beneath that whole movement have been provided by the judiciary wrongly. And if they had not done that, we may not have had that movement in this country. And so, so I'm trying to explain the role of the judiciary in this and predict that if we don't correct this, then we are in trouble. And because we are heading towards autocracy, and we will simply not, we are going backwards. Because as Justice Gajendra Gadkar said, to be a Hindu, you have to look to the past. So precondition, mandatory, right? So we have to look forward. We have to move with a whole world that is looking forward. There are many people in the world looking backward. So it's not that we reject everything we have, but as Narayana Guru says, we have to be critical. We look everywhere, take what we like from what is we consider, what we are familiar with, what we are not familiar with, and find a recent way to move forward. One of the issues I had flagged for a doc, there are also some doctrines that should have been there and are not there. And so, for example, the doctrine of recent thinking, rationality, scientific temper, which should have been strongly sort of propagated by the judiciary in its actions, its speech, in its support, is actually being reversed. And the judiciary is promoting, look at the addendum to the supremely crucial Ram Mandir, Babri Masjid judgment. That addendum is pure sort of religious belief, right? So are we promoting scientific thinking and inquiry when you have in such an important judgment an addendum which simply sets out superstitious belief, right? So this is one of the doctrine that should have been there but is not there, that that promotes doctrines that promote scientific thinking. So, but ultimately, I think two things for academics. One is, I think we must take the responsibility to produce material, and I must take the responsibility to write all this up. For example, I must walk my talk. And second, I think we should have, and this is to the Honorable Vice Chancellor, who is the distinguished Vice Chancellor, that we should somehow put a lot of theory back into the curriculum. When we were all in college, we had very, very wonderful teachers who taught us a lot of theory, Professor P.K. Tripathi and so many, I don't want to name them. They were wonderful teachers who taught us a lot. So if I'm able to say anything now, it's only because of those teachers, right? So we must not let these young people miss that opportunity. Thank you very much. Thank you. Thank you. I just want to say thank you, first of all, to the students who are here for their patience, their attention, and their wonderful questions. And I enjoyed that. I learned from you. I engage in all this to learn, actually, from you. I learned from everyone. And so thank you for that. Thank you to also Justice Bhatt he's the one responsible for asking me to come here and for giving me this opportunity for which I'm very grateful to him. And to Mr. K.K. Venugopal and the chair and Suhasini, and of course, to Malavika, who first contacted me on this, and as well as Roji and the wonderful brilliant young students here who I had a lot of interaction with and from whom also I learned and benefited a lot. Thank you very much. I do want to say, thank you so much. And I do want to say that I'm happy to stay here. I'm only leaving the morning tomorrow. If anyone wishes to stay back and have a conversation, I'm here. Thank you so much. Thank you. Thank you so much. Thank you. Thank you so much. Thank you. I'm a great admirer. Oh, that's very kind of you. Coming from you, it means a lot to me. You're someone I have huge respect and admiration for. Yeah. Thank you. Thank you. Thank you. I'm very grateful to you. Thank you. Thank you.
I think Professor Dhanda said it all, and I really don't want to take too much more time. I'd rather turn the stage over immediately to Justice Bhatt, who I'm sure will sum this session up much better than I can. So, Justice Bhatt, if you could.
Dr. Mohan Gopal, Vice Chancellor, my Professor Dhanda, my dear students and participants. I'll now read out what I did not read yesterday. I wanted to speak about the Constitution and then say, I only place a context, a broad canvas before you as a brief background to what promises. Now, this is where I am vindicated. To be a thought-provoking analysis by Dr. Gopal of where we are as a constitutional democracy, why we are where we are, and the interpretations of the foundational document, and what, if any, are the steps that we need to take in the ongoing tryst with our constitutional project. And I'm not unhappy that I spoke this in the end, because I think Dr. Gopal fulfilled every word that I kind of anticipated. I unashamedly say that. It was indeed very thought-provoking. And the best thing about it is that he tried to declutter our minds about most of the dearly held, not just concepts, doctrines which are seen as constitutional, let's say, as Professor Dhanda said, mantras, constitutional, something which is embedded or carved in stone. So I think it's time that we revisit it. And according to me, in the scale of things, the two important features that he identified, the non-discriminatory provisions and their deep-rooted the history associated with it. And I remember having a conversation with Dr. Malvika about how sometimes when we distance ourselves from history, we arrive at grotesque results. And therefore, I think Balaji or, for instance, Champakam were those examples. And going forward, I've been questioning myself internally about classification. And but then what troubles me is if we discard classification, where does it take us? What is the alternative? Because if a constitutional doctrine or practice is to be substituted, we should have something readily available. And I think that's where this whole process has to begin, from places like here. And that the thought leadership provided by these kind of lectures is bound to be invaluable. Even his thoughts on religion and where we started going wrong in our interpretation, in the judiciary's interpretation of that, and many of the dearly held beliefs which we associate as a part of the lore of the Constitution will have to be revisited by every succeeding generation. I don't think I can say more than that. And it's been very gratifying that every lecture of Professor Gopal has been completely so widely attended and with great deal of rapt attention. I don't think we could have asked for more, or the university could have asked for more. That itself is an indication of Dr. Gopal's enduring, let's say, relevance to the students here and the topics that he has chosen. In the end, I would only again reiterate that I would give a lot of credit and express gratitude to Mr. Venugopal and Professor Rao, who has facilitated and tried to be here despite his busy administrative, calendar, and the other members of the faculty, prominently Dr. Dhanda, and all my dear, I won't call them assistants because they have been the drivers of this idea, starting with Suhasini, Malvika, and Raji, and last but not the least, Professor Vasanti, who has led this whole team. I won't call that as her as a part of that team. She's in fact one of the principal drivers. So thank you all. I think that with that I would close that, except that those of you who wish to make any observation and continue with Dr. Gopal, he's here, as he said. Thank you very much.
Thank you so much, Justice Butt. Just one thing, I think what people wouldn't know, we were discussing who we could invite for this, and it was actually Justice Butt who said we must have Professor Gopal, and I think that was an absolutely wonderful choice, and I'm sure everybody agrees. I would just now like to invite the Vice-Chancellor and the Registrar to hand over a small token to Professor Gopal and perhaps say a few words also. I just want to say my thanks again to the Vice-Chancellor and to everybody at NALSAR, especially the students. I understand you guys are overburdened, and we are so happy that you guys turned up here. This was really for you, and we hope that you enjoyed it, and we hope that you'll participate when the center does more things in the future. None of this could have been possible without the Vice Chancellor's support, and of course without Professor Vasanti's support. So all credit to them as well. Sir, if you could, and ma'am, if you could now just...
Professor Mohan Gopal. Mohan.
I think with that, we close the program. Thank you once again, everybody. Oh, I'm so sorry. I left out Justice Bhatt's memento. You also get one, sir. Think that's it for us, everybody. Good night. Thank you once again for coming. The center is actually looking for feedback from students on the lecture and on other activities that you think we can do. So we are here on campus till tomorrow. So anyone who wants to reach out, please contact any one of us, Malvika, Raji, or me. Oh yeah, and if anyone wants to stay back right now to do a Q&A with Sir, he's available. We are just out of time for the formal session, but Sir is here, so please feel free to stay for a Q&A.
Thank you.
Yeah, inviting Adam back is one of the best things that we should have. That